November 2022.
Just a minute, just a minute.
Without interrupting the proceedings. May I have your lordship's leave to make a prayer? I am appearing, as your lordship knows, for added respondents. I appear in this matter on behalf of the added respondents.
Yes.
Basically, I have to adopt Mr. Datta's submission, but I have certain things more to say. So, Lord, I was praying that after the state sites, that is Mr. Datta and Mr. Sutanu Patro, they finish, kindly permit me half an hour's time on Friday.
Very well, very well, very well, very well, very well.
Grateful.
Now, what do you?
The 15th of November 2022, my lord, this writ petition has been affirmed. Now, my lord, I would like to, my lord, dissect this matter.
15th of November 2022.
Yes.
One day.
Yes.
But I would like to, my lord, dissect the cause of action, weigh the reliefs in this writ petition into two parts. One is, my lord, the reliefs or the cause of action pertaining to the first SLST, and the second is creation of the supernumerary posts. Now, my lord, now, my lord, so far as, my lord, the first my lord, compartment is concerned, pertaining to, my lord, the first SLST, please have a look to, my lord, an order, unreported order, my lord, of your lordship. My lord, just a 1.5 page order, where your lordship was pleased to, my lord, reject or dismiss a petition relating to, my lord, the first SLST on the grounds of delay. And I would submit, my lord, please have a look to it. The petitioner participated in the first SLST for recruitment of so-and-so in the subject work education, physical education under so-and-so category, failed to qualify the selection test. Petitioner is paying for a direction upon the West Bengal so-and-so to disclose the result of the said test. Dr. Patro submits that the panel expired long back on December 11, 2019, and the present petition has since been filed long 5 years after the expiry of the panel, is liable to be dismissed on the ground of limitation alone. The panel, since already expired long back, no fruitful result would be served by directing the commission to disclose such and such.
Yes.
Here also, my lord, before your lordships, my lord, the writ petitioners are unsuccessful in the work education or physical education?
Work education and physical education.
No, khali actor. I think in the work education category.
No, these
First paragraph.
two petitions have been clubbed together in one. Mr. Kalyan Bandyopadhyay is. It's analogous hearing. You may address on two.
It's like the application. No, it's like the private.
No, in the other writ petition, the analogous hearing. You may address it. So overall hearing.
Be that as it may, my lord, here also, my lord, persons similarly situated, my lord, having participated in this group, work education, physical education, unsuccessful, panel published, panel expired, then, my lord, comes before the court when, my lord, some supernumerary posts are created. But I would respectfully submit, my lord, this writ petition should also, my lord, face or have the same fate as the one, my lord, your lordship has been pleased to, my lord, dismiss. Now the alternative argument. Assuming, my lord, your lordship can be invited, or the court can be invited, my lord, after such a long time, my lord, to go into the matter. Assuming it to be so, my lord, my second limb of submission would be, my lord, a remedy which is barred
Yes.
As on 19th of May 2022, that is the creation of the posts. 19th of May 2022. My lord, please consider, my lord, whether that remedy can be revived. Simply because there has been some further developments in the matter. Or in other words, my lord, the question is, for your lordship's consideration is, my lord, whether 19/5/2022 will revive a cause of action or the right to move to the court, or, my lord, the liability of the defendants or respondents to answer to certain so-called affectation of rights, my lord, on the issuance of or on the creation of supernumerary post. My lord, in my very respectful submission, my lord, a remedy which is barred already cannot be revived by way of subsequent, my lord, causes of action. This would be my second limb of argument. The third limb of argument is, my lord, whether at all creation of the supernumerary posts can be questioned or challenged or, my lord, put for judicial review, my lord, in view of, my lord, the constitutional bar and, my lord, the, of course, my lord, the locus of the petitioner. But these are, my lord, fundamentals of my argument. Well, so far as the first one is concerned, but I have completed it will not
Please,
take.
yes, yes, I have already completed.
Now kindly take, my lord, so far as the second part is concerned. If it is barred, it is barred. My lord, there are judgments galore, my lord, right now, my lord,
You have already, so far the limitation point, you have addressed it on the point of merit.
yes, that's over.
Now, please come to the question what I last put you.
Right.
That
right.
your policy decision vis-a-vis the scope of judicial review, which has been very nicely crafted in your written notes of an argument.
Yes.
Please take me to those decisions from.
Yes. First, my lord, your lordship may kindly take, my lord, paragraph number 6.
Yes.
In paragraph 5, my lord, I have said that they are unsuccessful, therefore, para 6. Petitioners cannot have any grievance over the policy to create supernumerary posts since they could not prove their merit to be impaneled in the merit list or in the wait list. The judgment in SS Goel at para 23 holds one fails to understand what grievance the petitioners could have against the scheme. They were not eligible for being considered for supernumerary post as per the scheme. They have thus no locus standi to challenge the same. The judgment additionally proceeds to deal with the point of locus as well and held that people ineligible to the supernumerary post have no locus standi to challenge the same. Since creating the supernumerary post is a policy matter of the government, wherein the constitutional courts under Article 226 have refrained from interfering, the judgment in SS Goel, para so and so is relied upon in this regard. We are pausing here for a moment. Merit list could not, their names did not figure. Wait list, their names did not figure. Supernumerary posts, right or wrong, my lord, created for the wait list candidates. Therefore, my lord, the writ petitioners, apart from other things, my lord, do not have any right to challenge it. Why? Because even otherwise, my lord, they could not be accommodated or they could not prove their merit to figure in the wait list for which, my lord, the supernumerary posts have been created. Or in other words, my lord, I would be very respectfully submitting, my lord, in a very, my lord, casual manner, if your lordship permits me to use this expression, my lord, they are strangers to this entire process of creating the supernumerary posts and, my lord, the proposal to fill those posts from amongst the waitlisted candidates. Now, please have a look to me at this judgment, my lord. It is, my lord, at page
73 থেকে start.
73 of my compilation. Please take note the question frame, my lord, in para 1. The first question. Whether the scheme of the university grants commission to endow 3 posts of supernumerary professor to Delhi University for appointment of respondent so and so as welcomed in such and such could be accepted and implemented by the Executive Council without contravening section so and so, which stood prior to such and such. Well, the first distinguishing feature is this is not a cabinet decision, this Delhi judgment. This is, my lord, under the statutory functioning or by a statutory functionary to, my lord, create certain posts for the purpose of accommodating X, Y, or Z. Now, please take, my lord, page number para 23 at page 83. In summing up, well, I don't think I need to trouble your lordship with the entire paragraph. Well, please take, my lord, please take the last 4 lines. I don't think, my lord, the entire thing has to be read. One fails to understand what grievance the petitioners could have against the scheme, that is creation of supernumerary post. They were not eligible for being considered for the supernumerary post as per the UGC scheme. They have thus no locus to challenge it. Then, we are skipping over para 24. Please take para 25. The locus standi of the petitioners to file this writ petition is based only on the fact that some of them were and some of them are members of the council, academic council of the university. As such, they may be interested in preserving the status, powers, and duties of the academic council for being circumvented by the executive council. But once it is held that the UGC and the executive council together could implement the UGC scheme without the need for participation of the academic council in the process, the amendments made to the statute became unnecessary. It is only invalid amendments as would give a cause of action to the petitioners, since they have neither the cause of action nor the locus standi to file the writ petition. The writ petition could be dismissed on that ground alone. Assuming, however, that the amendments to the statutes were invalid as trenching upon the status, powers, and duties of the academic council within the meaning of section 29, a further question would have to be considered. Substantial justice has been done when academic council was consulted, but etc. I don't think that those are that relevant. And finally, the writ petition was dismissed. Next, your lordship may kindly take para 14 of my notes, because the petitioner's content that had the state allowed these or thrown open, my lord, these supernumerary posts for appointment to the public at large, then my lord, the petitioners could have participated, could have may have proved their worth. So this is, my lord, a submission, my lord, which has been made. But to that, my lord, kindly take note paragraph 14 of my notes. It has been contended on behalf of the petitioner that if a selection process is initiated in respect of the supernumerary posts, the petitioners could have offered their candidature and availed of an opportunity for consideration, and the petitioners could have proved their merit. Such submission of the petitioners cannot be entertained, since no one has a right to insist initiation of a recruitment drive. As discussed above, supernumerary posts have been created to promote the objectives of Article 21A of the Constitution and corresponding provisions of RTE Act, which may be achieved without taking recourse to a fresh selection process. It is not the case of the petitioners that waitlisted candidates are ineligible to be appointed. The case argued is of expiry of the panel of the waitlisted candidate. The Honorable Supreme Court in so and so have held that where selected candidates are available for appointment, there should be no hesitation in directing the authorities to appoint the selected person, even in a situation where the selection was over and the first candidate selected joined the post and resigned after a few days. But this is a decision where what happened is, of course, where this is for one post, not Millard, so many hundreds and thousands. But the principle would apply in my very respectful submission. But the selection was held. The first candidate joined the post. There was somebody waiting, second or third. The gentleman who joined the post resigned after a period of time. Therefore, the selection process is over. So the question arose, will the or is the authorities, recruiting authority or the selection body has to do it once again when they are
The
asked?
second one should be given there.
Yes, this was the point. Now,
Supreme Court says that even then the second one can be
Can be
considered when
given.
he is available.
yes, because these are eligible people.
Where is that judgment?
Millard, I doubt, Millard, whether a copy is there in the compilation. But kindly permit me to hand it up. Arun Kumar. That too? Hoga to de- make- I did not find it. No, it was in my notes, but Millard, it is missed in the compilation.
Oh,
Sorry. Citationটা হচ্ছে 2000 volume 1 SCC 600.
Huh?
But this was in the case of a tribunal.
you have handed over me. What is the cost title of that matter?
Where this matter, this judgment, AP Agarwal, Arun Kumar. Hey, no, sorry, sorry.
আগারওয়াল আলাদা, বলুন আলাদা।
It's for the next court case. Yes, come. I'm so sorry. AP Agarwal.
এপি আগারওয়াল
না, এটা ওইটাও আগরওয়াল।
হ্যাঁ,
AP
এটা
জায়গায়
AP,
অরুণ
ওটা
কুমার হয়ে গেছে।
হচ্ছে
পাশে করে কি হলো?
টাইম দিয়েছে এক সপ্তাহ, বিলে যেরকম অসুবিধা আমি করে চেঁচামেচি করছো।
very well. Agarwal is here. That
Agarwal is here, A is also here. Instead of
P and K.
P
and K.
and K.
Difference is P and K.
এই যে ওইটাই 2000 ও না,
না,
sorry,
2000
sorry.
ভলিউম 1 এসএসসি 600।
সাইটেশনটা ঠিক বলেছি। But your lordship may kindly take me to paragraph number 11. Millard, I have, Millard, kept on, Millard, harping before this court in this matter that there is a larger interest or a larger aspect of the matter. That is education for the students, which has ripened into a fundamental right today for children between 6 to 14. Now kindly take me at paragraph number 11. In our opinion, this is a case of conferment of power together with a discretion which goes with it to enable proper exercise of the power, and therefore it is coupled with a duty to shun arbitrariness in its exercise and to promote the object for which the power is conferred, which undoubtedly is public interest and not individual or private gain, whim or caprice of any individual. Even if it is to be said that the instructions contained in the office memorandum are discretionary and not mandatory, such discretion is coupled with the duty to act in a manner which will promote the object for which the power is conferred and also satisfy the mandatory requirements of the statute. It is not therefore open to the government to ignore a panel, where I harp over here, ignore a panel which was already approved and accepted by it and resort to a fresh selection process without giving any proper reason for resorting to the same. It is not the case of the government at any state that the appellant is not fit to occupy the post. No attempt was made before the tribunal or before this court to place any valid reason for ignoring the appellant and launching a fresh process of selection. It is well settled that every state action in order to survive must be susceptible, etc., etc. But these are all well settled principles. 12, 13, 14, 15. I don't trouble your lordship with all those. These are judgments which have been cited, and kindly take para 16. In the circumstances, we have no hesitation in allowing the appeal, directing the respondents to appoint the appellant as a member sales tax appellate tribunal, as he is the only other person in the panel of the names selected by the select tribunal and nothing so. But this is a reverse case. State thought that I have exhausted my, the authorities, I have exhausted my power, selection over.
For a fresh selection to be
Went for a fresh selection, the court said that
the second person challenged it.
yes, that why have you thrown it open for a fresh selection? The Supreme Court says that no, unless you have got very good reasons, selected candidates are available for you, appoint them.
If the eligibility is questioned and
But the eligibility is not questioned over here. And I respectfully submit, these are all, of a much lower pedestal. Judgments on actions which have fallen for the consideration of the courts in the various judgments that I will be citing or my learned friends have cited are on a very lower pedestal. But our case is of a much higher pedestal, where cabinet takes a decision and it has a constitutional protection. I'll come to that later on. But principally, I am submitting whether principally it could be done or not. Principally, I have conducted the selection process. I had prepared 2 merit lists, 1 merit list appointed given. The other merit list is the waitlisted candidates. Waitlisted candidates have also proved their merit. Therefore, I also call it a merit list. Now, from amongst the persons, the waitlisted persons who have proved their worth or proved their merits, I have created supernumerary posts. Why? For the children, and fill them up with those who have already proved
together your constitutional obligation under Article 21.
Yes, 21A is there. The provisions of the Right to Information Act is there, which provides me, confers me with an obligation to make available teachers for the students or quality teachers for the students.
Yes.
Then what is a supernumerary post and all that? I don't think I need to make submissions on that. Kindly note, paras 12, 13.
Of that judgment or?
No, para 12, 13 of my notes. I'm so sorry, 12 and 13, kindly note in this regard. But the judgments with those are also
with regard to the definition of supernumerary.
Yes.
That is, I don't think that you need to.
I don't think that I need to waste your lordship's time on that.
Yes, I will go through these judgments. I will go through these judgments.
Very well. Then, your lordship may kindly take, what I have right now said, para 10, 11 of my notes.
10
and 11. Please have a look to it only, I don't think I need to.
Yes, 21A, you have explained your obligation under 21A.
Right.
Now, 11 is important.
Yes. But I'll take it, as my last point. So, for the timing, your lordship may skip over, paragraph 11. Now, please take paragraph 15.
15.
Yes.
Yes.
But this is what I have already submitted yesterday, that my power to create post cannot be questioned. Just look into that, Millard, paragraph 15.
It cannot be questioned.
Millard, as a continuation to that or a corollary to that, kindly take para 16.
আশা করে কি বলছে এখন?
এখন ফিরদৌস সামনে।
আমাদের বাড়িতেই বলছে।
এখন ফিরদৌস সামনে। বিকাশ দা হয়তো মামলা থেকে ভ্যানিশ হয়ে গেছে।
Yes.
Then, Millard, as I've said, please skip over 2 paragraphs. Kindly take paragraph number 19. Waitlisted candidates, Millard, by judicial dictum has been held to be qualified or eligible candidates. This is, Millard, para 19. With that, Millard, the judgment in Gujarat State Executive Engineers Association.
হ্যাঁ আমি একটু
এসব অবিটার ফবিটার কি জ্ঞান দিচ্ছে নাকি?
শুরু করেছি, আমি শুনলাম না তো চলে।
শুনতে পাচ্ছিস তো? বোঝার চেষ্টা কর।
আমার কনসেন্ট্রেশনটা এদিকে।
Now, Millard, in connection with para 19, please come to Millard, page 93 of the compilation, judgment compilation. So the judgment starts at page.
কোনটা?
94.
So the
Supplement two.
judgment starts from page 86 of my compilation,
Yes. This is 94 supplement. two.
supplemented to SCC 591 Gujarat State Deputy Executive Engineers Association. Now, please take note paragraph 8 of this judgment. Where in our case, Millard, the wait list is creation of the wait list is not under challenge. Kindly take para E. The Supreme Court explains what is a waiting list. Coming to the next issue, the first question is, what is a wait list? Can it be treated as a source of recruitment from which the candidates may be drawn as and when necessary? And lastly, how long can it operate? These are some important questions which do arise as a result of the direction issued by the High Court. A waiting list prepared in service matters by the competent authority is a list of eligible and qualified candidates who, in order of merit, are placed before the last selected candidates. How it should operate and what is its nature may be governed by the rules. Usually, it is linked with the selection or examination for which it is prepared. For instance, if an examination is held, say, for selecting 10 candidates for 1990, and the competent authority prepares a wait list, then it is in respect of those 10 seats only for which selection or competition was held. Reason for it is that whenever selection is held, except where it is for single post, it is normally held by taking into account not only the number of vacancies existing on the date when the advertisement is issued or the application are invited, but even those which are likely to arise in future within a year or so due to retirement, etc. It is more so where selections are held regularly by the commission. Such lists are prepared either under the rules or even otherwise, mainly to ensure that the working in the office does not suffer if the selected candidates do not join for one or other reasons, or the next selection or the examination is not held soon. A candidate in the waiting list in order of merit has a claim, has a right to claim, I'm sorry, has a right to claim that he may be appointed if one or other selected candidates does not join. But once the selected candidate join and no vacancy arises due to resignation, etc., or for any other reasons, within the period the list is to operate under the rules or within the reasonable period where no specific period is provided, then the candidate from the waiting list has no right to claim appointment to any future vacancy which may arise unless the selection was held for it. He has no vested right except to the limited extent as above, or when the appointing authority acts arbitrarily or makes appointment from the waiting list by picking and choosing for extraneous reasons. Therefore, waitlist candidates are also meritorious candidates. They are also eligible
From this
candidates.
judgment, we can gather this much.
Yes.
This much.
But these are all judgments, again, my lord, at the risk of repetition, these all operate, my lord, within the statutory field or in the subordinate legislature field. Now, the principles which apply, my lord, in the primary legislation field or, my lord, subordinate legislation field, my lord, whether, my lord, an action of the cabinet can be interdicted on any other principles or upheld, requires to be upheld on these principles which even apply or operate in, my lord, a much lower pedestal.
So how you are harping on this is a cabinet decision
Yes.
policy.
But I would like to, my lord, express myself in a way that what I have done or the entire what should I say, my lord, the actions in filling up this post are, number one, not illegal, not unknown, not disapproved by courts, rather approved by courts, apart from the locus and etc., assuming they have the locus, assuming they can come after 4 years, assuming that supernumerary post creation gives them a cause of action to move a writ petition, assuming everything in their favor for the time being. They'll also, my lord, the activities or the actions which are before your lordship, my lord, are, number one, not unknown, and number two, has been approved where situations demand it.
Take a note of it.
Now, my lord, the very shiny, my lord, argument nowadays, corruption. Here Supreme Court interfered, there Supreme Court interfered, without, my lord, bringing the core matters on the surface. One sentence, half sentence from here and there, and, my lord, trying to create an impression upon the court that everything is vitiated by corruption. But in my very respectful submission has become, kindly permit me to say this, my lord, a very, I would not like to, my lord, use negative words. My lord, a submission, my lord, which is often, my lord, portrayed before the court without placing the entire gamut of the matter. Why I say this? Time and again, in this proceeding, Boishagi Bhattacharya's judgment has been referred to. Why?
That would be my next question to
Yes.
you.
Why?
No,
They-
no, stop here for a
Yes.
moment. Now, why this situation is? Now, this was, you did all civil service matters. It was the conception that state is the model employer. It will be always presumed when a statutory body is conducting the recruitment process. Presumption would be that fairness, the adherence to the rule, presumption would be that. Now, why this situation has developed today? Nonetheless, a selection process which has been annulled by the Honorable Supreme Court, up to the Honorable Supreme Court, with the finding of this corruption and other things. It is hard reality, Mr. Dotto, you have to accept. And it has got a huge impact on the society at large. Therefore, it has got an impact on the courts also.
Yes.
So, therefore, it is very easy for the at the threshold to throw all these claims. You are unsuccessful. Supposing a student is coming in the field of review, reconsideration paper, the presumption is you have failed, try for the better luck next time. But court never, even the parents did not indulge upon that questioning the teacher that what you have done, why my sons has now been failed in the examination. But this situation, when if it is exposed somewhere,
Nowadays, where the situation has changed. Nowadays, parents come to court. Why have my son?
exactly, in this court,
Where your parents and our parents.
No, no,
do not
never.
Think of it.
neighbor, I'm giving you one example. এটা বন্ধ করো।
Rajiv Brahmota there? Yes, there is a division bench judgment which was upheld by the Supreme Court,
Supreme Court,
review also
yes, yes.
dismissed by the Supreme Court. But this, my lord, will find, my lord, in the before that, my lord, please take me paragraph 20 of my written notes, where, my lord, I have referred to, my lord,
Yes.
reliance on Boishaki Bhattacharjee, Chatterjee, Bhattacharjee and Chatterjee.
Not Banerjee, no?
No. But who's Banerjee? I don't know anywhere.
What is that?
Well, some people are more familiar with female names. I'm not familiar, you know that.
Don't lie in the morning. Then,
No, don't say anything to me because after all, it becomes a judicial dictum.
of course, this is a difficulty.
Now, my lord, para 20, my lord, kindly have a look to, my lord, the written notes.
Yes.
Many things must be creeping into your lordship's mind, which had happened 30, 40 years back.
One cannot. And with the age, with the growing age, it comes very often.
Yes. And more particularly when you follow your next generation.
Yes. They did not do it. They are enough to do all these things.
No,
They are very good.
no,
The next generation
may
is
not have all the information. Like you withheld many information.
risky information technology nowadays.
Yes. But nowadays, my lord, even, my lord, children can be, my lord, followed through mobile also.
Yes.
Yes. You can stalk your children
But
through
Mr.
your
Dotto,
mobile.
they do not share that much of this friendship platform. They are deprived of.
Yes, yes.
What? They are really
But I
deprived.
personally feel, speaking for myself, I am very insensitive.
Boishaki is not applicable.
Yes. But please take, my lord, the last two lines of that page of my written notes, page number 6. Such submission, that is reliance on Boishaki, is contrary to a judgment and order dated 28th of August 2024 rendered by the Honorable Division Bench of this court in the case of Rajiv Brahmo versus State, reported in so and so, wherein The recruitment process in respect of assistant teachers in upper primary except physical education and work education has been upheld by the division
Yes,
bench.
yes, yes. This was upheld and affirmed by Supreme Court. Review petition dismissed.
Yes. But
So upper
kindly note
primary
down the page numbers only, Mayor. I will not trouble your lordship. The 2024 SCC online 7948.
184.
This your lordship would find Mayor at page
84
184.
it starts.
you know,
And Mayor, the relevant portion at page 207.
184.
Yes, it starts at 184, relevant to 207.
দেখুন, এই ভলিউমটা শুরু হচ্ছে তো 200টা এই কাগজটাতে নেই লাগে ট্রেনের নোটটা
It's paragraph 41 at page 207. But just Miller to show that it has been upheld. Forty-one, 42, 43. But SLP therefrom dismissed. This is page 210. And review dismissed, page 212.
212.
Yes.
It is ended in my copy 211.
But there's a second volume. Miller.
This time oh, second volume, huh? Yes, 212. রাজীব ব্রহ্মা এ ধরো এটা
Therefore, Miller, my conclusion on this aspect is para 23 of my notes. The petitioners claim to have applied for the post of assistant teachers in so-and-so on first SLST. Panel was published on so-and-so for work education, physical education. The last appointments was made in March 2020. Petitioners did not show any contemporaneous challenge to the selection process till such time the notification dated so-and-so were published. The writ petitions were affirmed. Creation of supernumerary posts cannot confer on the petitioner cause of action to challenge the selection process, not challenge contemporaneously. The petitioner have acquiesced to the entire selection process and have waived their rights in respect of prayers A, B, C, D, and E. Now, Milord, the main point. Prayer F. Para 24. Then, my lord, I have spoken of, my lord, Control Expenditure Act,
Hmm.
para 25.
These are all government action.
Yes. Then 26 is section 19 of the School Service Commission Act. Then, when I have spoken of, my lord, that cabinet decision was not looked into, or, my lord, interfered with in Boishaki Bhattacharya's case. This is para 27. Same is para 28. Same is para 29. Now, please take para 30. But this is the interplay of various provisions of the Constitution, my lord, para 30. Now, may I place para 30 and then, my lord, the relevant decisions. It is submitted on behalf of the petitioners that the decision to create supernumerary post has not been made by the Honorable Governor. But according to them, the Governor ought to have done it. My lord, as your lordship know, my lord, that the Governor has got various responsibilities. It is not possible for the Governor to discharge all responsibilities alone. Or in other words, all the files should not go before the Governor. All the decisions should not be taken by the Governor himself personally, unless those which under the Constitution is to be taken by the Governor at his discretion. Only those decisions. The other decisions for the other activities of the Governor, my lord, under Article 166, sub-article 3, my lord, the rules of business are framed, under which the various powers of the Governor, my lord, are being distributed amongst ministers, secretaries, officers, etc. Now, when these ministers, secretaries, etc., my lord, they take the decision under the rules of business, those decisions become the decision of the Governor himself. The only exception is where the Governor has to take decision at the action under his discretion. Otherwise, he is guided either by the officers or by the cabinet, council of ministers, which is, as your lordships know, it's called collective responsibility. Now, a short discussion on this, my lord, in para 30, because the petitioners want that the Governor is completely unaware of
The
This-
cabinet decision.
this cabinet decision or creation of this post, and therefore it should be interfered with. Such submission of the petitioner is contrary to the constitutional scheme. Article 154 of the Constitution provides that the executive power of the state shall vest in the Governor and shall be exercised by the Governor either directly or through officers subordinate to him in accordance with the Constitution. Article 162 of the Constitution provides that the executive power of the state shall extend to the matters with respect to which legislature of the state has power to make laws. Article 163 of the Constitution provides for a council of ministers with the chief minister as the head to aid and advise the honorable governor in the exercise of his functions, except those which are required to be exercised by the honorable governor in his discretion. Article 166 of the Constitution provides that all executive action of the government of a state shall be expressed to be taken in the name of the governor. Then 166.3 protection, where I have said Article 166.3. No, 166.3 is the rules of business. I'm so sorry. Article 166.3 of the Constitution of India provides for making rules by the governor for allocation amongst ministers, government business, except those which the governor is by or under the Constitution required to act in his discretion. The combined effect of the aforesaid articles and several other related articles in the Constitution fell for consideration before the 7 judges Constitution bench of the Honorable Supreme Court in the case of Shamshed Singh. Though the judgment pertains to the power of the governor under Article 234 of the Constitution, however, the Honorable Supreme Court analyzed several powers of the governor and laid down the law as to which of those powers are to be exercised by the governor personally at his discretion and which of the powers are to be exercised through officers. Honorable Chief Justice A.N. Ray delivered the lead judgment by inter alia holding that the Honorable Governor is required to act in his discretion personally only those functions which are mandated by the Constitution. Article 166(3) has been analyzed by the Honorable Supreme Court to hold that the Honorable Governor will not be constitutionally competent to exercise the other executive powers of the state without the aid of the Council of Ministers. The Honorable Supreme Court traced the articles of the Constitution which requires the Honorable President of India and the Honorable Governor of a state to act in their discretion. The Honorable Supreme Court further held that neither the Honorable President nor the Honorable Governor exercise executive functions individually or personally, and that the executive action taken in the name of the Governor is the executive action of the state. Executive power has been described as a residue which does not fall within the legislative or judicial power. However, executive power may also partake of legislative or judicial actions. The Honorable Supreme Court further held that the decision of any minister or any officer under the rules of business is the decision of the Honorable President or the Governor, as the case may be. Provisions like Article 163 of the Constitution of India are for discharge of executive powers and functions of the government in the name of the Honorable President or the Governor. Ministers accept responsibility for every executive act of the state. In a concurring judgment, the Honorable Justice Krishna Iyer quoted the advice of the first learned Attorney General of India to the first Honorable President of India and the first Honorable Prime Minister of India inter alia that aid and advice in Article 74 of the Constitution cannot be construed so as to enable the Honorable President to act independently or against the advice of the Cabinet. Honorable Justice Krishna Iyer went on to hold that even discretionary powers are not left to the sweet will of the Governor, and that the Honorable Governor cannot take up public stances critical to the government policy settled by the Cabinet or to interfere in the administration directly. Paragraphs so and so of Samsher Singh and Bhurinath are relied in this regard. But I have given these judgments from Samsher Singh and Bhurinath. Samsher Singh is page
39. 239.
Samsher Singh starts at so many paragraphs I have referred. It starts from page 239
আর এই ভুরিনাথটা হচ্ছে 298.
and Bhurinath at page 298. এটা বড় মীনাক্ষী আরোরা বলছে না মনে হচ্ছে না।
So governor will have two areas where he has to act independently and other to advise and aid of the. Now this particular, what their argument was that this was not
Placed before the government.
rooted through governor.
That is not required.
That is not required. It is a field where the
When you have distributed your powers, or the powers which can be distributed having been distributed, the officials with whom the power is vested after distribution, they take the decision, and when they take the decision, that is the decision of the government.
so these executive actions or the creation of supernumerary post in every tiny matters cannot be
Yes,
referred to
Yes,
for the governor for its ratification or sanction. So there are the specified fields where the governor's advice and it should
Yeah, I'll give you an example. Without summoning the assembly, that the governor cannot use powers. Adjourning the assembly, prorogating the assembly, can't. That the governor has to do.
what is how far the development is so far the government is sending bills and others for governors. It should be routed through escape pending.
Governor's function in his discretion under the Constitution.
But how far it can be kept pending on the Supreme Court?
The Honorable President has, my lord, invoked article কত জানো এটা 172 বোধহয় for the opinion of the Supreme Court.
So on this issue. This is not such a case.
This is not such a case. This is
So-
not a,
It is not necessary this policy decision, each and every policy decision should be routed through governor. That is your contention. Sorry. That is what exactly,
But I'm only voicing what the Supreme Court has said.
that is exactly very nicely and wisely, because now these overlapping areas, regular confrontation.
But the confrontation is because of so many reasons. Like I give you an example. I don't know whether I should say this or not. Now the question of Millard appointments of vice chancellors by the governor Millard has become a subject matter of discussion before the Supreme Court. So many matters. Millard, without considering, with respect, the honorable governors, without considering that when they act as chancellors of the universities, they don't act as a constitutional authority. They act as the head of that university, as the first man of that university. Now this mixing up of powers, or Millard not differentiating,
Is very difficult to,
it's like Millard, your lordship taking a judicial business and taking a chamber business.
supposing wearing your red coat, you have to put off the red coat when you are entering somewhere with a black coat.
Right.
This is it, but sometimes these coats are so tight, they do not want to remove it.
Yes.
Very difficult mindset
Yes, yes. Very difficult.
for some people, very difficult mindset.
Power to concern.
Then,
Power of the president to concern.
But this Millard, Samsay Singh Millard and Bhurinath kindly Millard, your lordship may consider.
yes.
Then Millard, I go to Millard para 31.
Hmm.
Settle law that Article 166 is directory, not mandatory, and if they are not complied with, it can be established as a question of fact that the impeachment order was issued, in fact, by the state government or the governor. But these have, I had to Millard put in my note because Millard of the contention that the governor, the matter was not placed before the governor or it did
Not
not.
very appealing. Please proceed on.
32, 33, these are all Millard, 32. Then 33 Millard, the protection.
Yes, this is important.
Yes. In respect of the same cabinet decision and the impeachment order dated 19th May, the Supreme Court was pleased to observe that the advice tendered by the Council of Ministers of the Cabinet to the governor shall not be inquired into in any court under Article 163.3. The Council of Ministers under 163 exercises the executive powers of the state provided under the Article 154 of the Constitution. The advice given to the governor by the Council of Ministers is protected under 163.3. The judgments in so and so and so and so are the like.
No, there is no question of coming the advice. You are not sought for any advice.
No, the advice, what does the state cabinet do? When the state cabinets will not function, they take a decision. This is a collective responsibility or the theory or doctrine of collective, this is a doctrine of collective responsibility, which the state cabinets exercises and will not transform into either a policy or an executive action or whatever, wherever they are to be implemented. Now, if the state cabinet will not takes a decision, the question is to what extent that can be scrutinized in court, or if at all it can be scrutinized in court. This is, Millard, a constitutional bar, like Millard Article 329B. This is a bar on the court.
That is what
like
Supreme
your
Court-
lordship's, my lord is much more experienced in the civil side, like res judicata. It's a bar on the court. No court shall do so and so, so and so.
No court shall proceed. Section 10. No court shall proceed.
So these are, my lord,
Are on the jurisdiction.
bar on the jurisdiction of the court. Therefore, when, my lord, Article 163, kindly have a look to my lord, Article 163 once.
दाओ आपका लो कॉन्स्टिट्यूशन बताओ.
Points.
Kindly see sub-article 1.
Yes.
There shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his functions, except in so far as he is or he is by or under this constitution required to exercise his functions or any of them in his discretion. So how does it happen? Those may I replace the expression discretion with the word personal. So under the constitution, the actions or the decisions which the governor has to personally take, there he has to take himself, or he does it himself. Otherwise, it is through, my lord, the aid and advice of the council of ministers, which is called the state cabinet, with the chief minister at his head, and, my lord, it is executed through the ministers, secretaries, etc., with whom, my lord, the functions are distributed. My lord, I'll come back to 163. Please take 166.
166.
All executive action of the government of a state shall be expressed to be taken in the name of the governor. Orders and other instruments made or executed in the name of the governor shall be authenticated in such manner as may be specified in the rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. Their case is that where do you find the involvement of the governor?
No such governor has not taken a decision.
Not required. That
And
is one.
according to you, this is not the field where we should seek the permission or the approval of the governor.
Governor. Yes.
There are
They-
some places left. Otherwise, how the council of ministers will act on?
Right.
Yes.
How do governor transact all these business which under the constitution is bestowed upon him? Please take sub-article 3 of 166. The governor shall make rules for the more convenient transaction of the business of the government of the state and for allocation amongst ministers of the said business, insofar as it is not the business with respect to which the governor is by or under this constitution required to act in his discretion. So whatever is left after those functions to be done by him personally, these are all, my lord, distributed amongst the ministers, which is called, my lord, the rules of business. Now please come back to 163. Where 163 2, my lord, may not be relevant for my case. Please take 166 3. The question whether any, and if so what, advice was tendered by the ministers to the governor shall not be inquired
The
into.
Supreme Court has made it clear.
Therefore, my lord, even otherwise also, even if there is any irregularity, but in my very humble submission, where there is a constitutional bar, my lord, in looking into it or inquired into by the court, but on this, my lord, I have relied upon these two judgments, AIR Bombay. I don't think that I need to rely judgments that only for the sake of it, my lord, I have relied upon two judgments.
This is all constitution is very clear.
And with the other things that I've dealt with, these are not that important. I mean, after
Very well, and so far the distinction of the judgments
I made
that-
somewhere in the
that you have made it,
yes, as short as possible. I've made it, Milord.
that you have made it.
Yes. After Milord, para 32, 32 ito.
Paragraph 34,
After 33, yes.
yes,
At paragraph 34,
you have
under
made all the
headings, Milord.
distinctions.
Yes.
So you need not read this.
No, I don't think so. I don't think so.
Very well. If I require any further assistance, I will call you. Dr. Patro, may I come back and after that I will hear. Then Mr. Shilpa.
But may I take your lordship's leave? Yes. I'm grateful.
And where is the board? The board, if he intends to add anything after you. All the authorities,
Very short because,
please let me come.
yes.
Make it short, precise, whatever way you can.
Yes, sit down.